Minister, I might just run through some of the stakeholder concerns and then ask you questions in relation to this particular Clause 1 question. So stakeholders have raised deep concerns with us regarding the use of the term integral in Section 93C 2A of this bill. This section provides that the court may consider in determining whether an individual is akin to an employee, including whether the individual carries out activities as an integral part of their activities carried on by the institution. Concerns include that there is no clear definition of this term and a potential to create a high threshold of proof that could exclude groups of people like volunteers. So similar newly passed laws in the ACT use the words ordinary activities in their equivalent provision. Stakeholders believe, as do we, that the ACT's wording is more appropriate. It recognises that institutions that benefit from volunteer work, which may not be integral, should still carry responsibility for the harms if they are part of the institution's ordinary activities. So I ask the Minister, can you clarify the intended meaning of the word integral in this clause?
Minister.
Thank you, Ms Payne, for your question. It is quite a technical one, but I can understand how words, especially when they're open to interpretation, can have a significant impact on all the parties involved. But I guess in terms of the interpretation of the word integral in this context, it is up to courts to interpret that language. The word integral is used in the bill as it reflects the Victorian Supreme Court. I know you referred to ACT jurisdiction, but it reflects our Supreme Court's 2023 decision in DP v Bird. And it's an approach that is used in New South Wales and South Australia, although they have a prospective vicarious liability provisions, not retrospective, so not as expansive as ours. But I think it's about providing that consistency, but it also reflects the language that has been utilised in our court system. But that will be up to the courts to determine. And I know you gave a reference of volunteers as an example, but I think who is or not akin to an employer will be up to the courts. And they will be able to interpret that legislation as they see fit and decide each case based on its unique facts.
Ms Payne.
Thank you, Deputy President. Thank you, Minister, for your response. Was the use of the term ordinary activities instead of integral considered in the drafting of this bill? And if so, why was it decided against?
Minister.
Thank you, Ms Payne. I think the goal was to provide consistency, and that was integral was the word used in the 2023 Supreme Court decision in Victoria, and it's also the approach consistent with what we see in New South Wales and South Australia. So I think the goal was to provide that level of consistency which reflects the Victorian Supreme Court decision of 2023 and return to that basis as the intention of this bill is.
Ms Payne.
Thank you, Deputy President. Minister, thank you for clarifying. Is the term integral intended to also apply to volunteers?
Minister.
Yeah, I think that's a really good question, because I know some of the stakeholders that did come out the concern of limiting its application to people and not cover volunteers. But I think whether a volunteer is akin to employment or employee, so to speak, will be for the courts, and they'll have to look at the facts, and they are difficult. So there is no blanket rule against volunteers being covered, but it would be the unique circumstances that the court will need to interpret in relation to integral and interpretation that they see fit in the circumstances of each unique case.
Ms Payne.
Thank you, Deputy President. Minister, thank you for your response. Concerns have been raised with me regarding Section 93C2B of this bill, and the section that encourages judges to place weight on the extent of the institution's control over the employee or person akin to an employee. They believe this may cause irrelevant considerations, like what a coaching system might entail, and believe if an institution has appointed a person to perform a particular role and the abuse has occurred within the context of that role, the level of control should not be a relevant factor. So I've got two parts to this question. Is the intention of this consideration to exclude volunteers or lower groups over who the institution may have a lower level of control?
Minister.
maybe start by responding to the second part of your question. I guess whether a court determines an individual to be akin to an employee will depend on how it applies the provisions to the unique facts of a case. So they are difficult because these are historical, and the way organisations operated in the past will need to be considered in light of these cases. But the inclusion of the extent of the organisation's control over the individual in the carrying out of their activities in the new section 93C2B has been included as one of the factors a court may consider. The factors in proposed new section 93C to represent a non-exhaustive list, and the court may also have regard to any other relevant factors. And I think that is important, again, so knowing that these are historical and the way that organisations have operated historically to how they operate now has changed dramatically. And so I think the court will need to consider the individual case and the facts around that in making that determination. But I think the courts have that discretion and be able to apply the discretion as needed.
Ms Payne?
Thank you, Deputy President. Minister, how is this consideration of the extent of the institution's control over the employee or person akin to an employee intended to operate?
Minister?
Thank you, Ms Payne. The factors in the proposed new section 93C of the Wrongs Act are discretionary and non-exhaustive. The court may have regard to any other matters it considers relevant when determining whether an individual is akin to an employee. So I think any other matters it considers relevant, it should consider.
Ms Payne?
Thank you, Deputy President. Thank you, Minister, for your response. So this bill does not contain a provision to the effect that the provision... Sorry, my eyes are skipping. This bill does not contain a provision to the effect that the provisions do not affect and are in addition to the common law in relation to vicarious liability. So, Minister, can you confirm how the legislation will apply with respect to the common law on vicarious liability?
Minister?
Insofar, this bill is intended to affect the common law doctrine of vicarious liability as it relates to child abuse. So it is limited just to child abuse. And if it's passed today, the amendments to the Wrongs Act would codify the existing common law of vicarious liability as it relates to child abuse, but extend it beyond employment relationships to include relationships akin to employment in order to address the impact of the Bird decision. This would have the effect of replacing the common law of vicarious liability as it relates to child abuse. So it would be limited, but only for children. The bill does not otherwise affect the common law doctrine of vicarious liability for other types of claims, and it does not prevent the court from considering other common law principles.
Ms Payne?
Thank you, Deputy President. Thank you, Minister, for your response. There have been calls by some to change the language of the bill to capture those associated with the relevant institution. These calls reflect concerns about church structures and responses to abuse that appear to have been deliberately opaque. Can you advise why the decision was made not to include those associated with the relevant institution in this bill?
Minister?
In terms of this bill, this provision, when I'm saying this provision, I'm referring to 93C3 in the Wrongs Act, clarifies that an independent contractor is not akin to an employee. This provision has been included to align with the common law, where an organisation cannot be held vicariously liable for the acts or omissions of an independent contractors. Genuine independent contractors are in no way akin to employees. Extending vicarious liability for child abuse to independent contractors would go well beyond what is required to remedy the effect of the High Court Bird decision. And also aligns with the prospective laws we're seeing in New South Wales, Tasmania, South Australia and Northern Territory.
Ms Payne?
Thank you, Deputy President. Minister, you did touch on this, but I might just reiterate what you talked about there around independent contractors. So this bill excludes independent contractors. And concerns have been raised with us about this exclusion and the potential for institutions like the church to try and use this to carve out this as a loophole to avoid liability. Can you advise why the decision was made to exclude independent contractors?
I think that's a really good question. That's always the concern. I guess that's someone that's worked as a personal injury lawyer in the past, but I know there's a few employment lawyers in this building that would tell you that these are concerns about people, sham contracting arrangements. But I think the courts are very well akin and aware of these issues, and so it'll be up to some defence organisers that may attempt to defend themselves by arguing the alleged perpetrator wasn't independent contractors, but the court will be able to apply the existing principles to determine whether someone is a genuine independent contractor, whether they're an employee or they're akin to an employee. So I think the courts are well trained in that kind of distinction because they are well tested. Unfortunately, there are people doing the wrong thing. So it is a really good question in light of that. Thank you.
Ms Payne.
Thank you, Deputy President. This is my last question. And Minister, you did also just touch on this around liability. So how will it be ensured that this does not create another legal loophole institutions can exploit to escape liability?
Minister.
Thank you, Ms Payne. I think that's right. I think there will, unfortunately, we know with a lot of laws, there will be people that will try to take advantage of it. But I think when you talk at the employee-employment relationship, and obviously now we're, for victims of child abuse, introducing akin to employee, I think the courts are well designed and well trained to look at these circumstances because they look at them in a range of contractual situations outside the child abuse space. So there's a lot of established law that they can rely on to work out whether someone is a genuine independent contractor or they fit into a employee situation and therefore would be held liable.